I am pleased to be joined by Mitch Kowalski, who's a candidate for Bencher in this 2015 election. Voting has now begun, continues until the 30th of the month. So let me say hello to Mitch. Thank you very much for joining me. We're going to talk about some issues today.
Great, thanks, Garry. Glad to be here and get out and vote.
Yeah. So I would say it's safe to say that you're probably one of the most interesting of the candidates because you bring such a different perspective to the table. When did you start thinking about running for Bencher? And can you maybe discuss a bit about your processes about how you got to this point?
Sure. This is actually the second time I run for Bencher. I ran in 2011, last election. And at that time was the time that I started doing a lot of writing, a lot of thinking about the future of the legal profession. And what I saw with the Law Society and with the legal profession in particular was we're behind the times. We need to move into the 21st century, and that requires change at the Law Society and the Benchers, and that was my start. And so, as you know, I've been writing and speaking about the future of the legal profession for years now. And so, next election comes along, and I'm hoping to garner your support.
You've been an outspoken but dignified critic of the Law Society for quite some time. Where do you see the immediate problems with the Law Society, and what are the immediate solutions?
I think the Law Society is a real governance issue. I think that convocation is very unwieldy at 40 benchers, and when you add in life benchers, and we're not allowed to have life benchers anymore, but we still have a slew of life benchers there that really, with all due respect to them, that's not good governance to have life benchers in there making comments and trying to sway opinions. That's not the purpose. So we need to get rid of life benchers. We need to shorten the terms even further to 2 terms rather than 3. 12 years is far too long for people to be benchers. 8 is a better number, and 8 gives that refresh where more people, a broader audience, a more diversified number of people can participate in convocation, and you need that refresh. And so that's where. And I'd like to see caps on election spending. I think we've all seen how much money some candidates spend, and that's great. Except most candidates can't spend that kind of money, and that needs to be leveled. The playing field needs to level so that a greater number of people can participate effectively in the election process.
Perhaps it's a criticism of the Law Society's operations, but I'll just make it as an observation for this purpose. Most lawyers have practically no idea at all what benchers do, and what the process is, and how decisions come to be made. Is there something you've observed over the last 4 years in terms of how the Law Society is operating at the bencher level that gives you great concern and can perhaps serve as an example of how change is required?
Sure. Benchers typically misunderstand their role. It's a board of directors role. They are the board of directors for the Law Society. So they should be using good decision making and good governance. They should not be looking to the lawyers in their jurisdiction for advice and following what those lawyers say. It's not a politicized process. It's not Parliament. It is not something that should be open to lobbying. And far too often I see benchers just going back to where their constituencies are, where their perceived constituencies, and saying, what do you think? Should I vote for ABS or not? Oh, well, if it hurts the people in Hamilton where I'm from, then I'm not going to vote for it. That's not good decision making. That's not what we should be doing at all. ABS is a great example. When we see candidates and benchers already having made that decision, no, we will not have ABS in this province. That's not open-minded, and that's certainly not good governance. That's not good decision. Coming pre-programmed is not what benchers should be doing, and yet we see that time and time again. We see a complete absence of objective, thoughtful approaches to how you reach decisions. We see decisions being made on programs where no one has determined what the metrics of success will be for that program. So if we go into an LPP program, how do we know 3 years from now it's been successful? We have to set those up front. We don't look back 3 years from now and just sort of kick it around and say, you know, guys, I don't think it really worked just because I got that gut feel. That's not a good decision.
When you think of the Law Society as a board of directors, I presume you're referring to the Law Society Act. And in terms of the statutory mandate the Law Society has and the statutory role the benchers have vis-a-vis the Law Society.
Act in the public interest. And I think there is difficulty with benchers separating interests of lawyers with the interests of the public. And clearly it's the public interest is first. And if that, impacts the commercial interests of lawyers, so be it. That is not the role. If you're concerned about protecting the commercial interests of lawyers, run for the CBA, run for OBA, run for OTLAW. But that's not the role of the regulator. So, that separation needs to be more ingrained with benchers and how they come to their decisions.
The Law Society Act specifically states that the Law Society has a duty to facilitate access for justice. What can the Law Society do to fulfill that statutory duty?
You know what I'm going to say.
Which I never know what you're going to say.
No, what the Law Society has to create an ecosystem in which lawyers can deliver services in a way that is accessible, affordable, and convenient to lawyers. And that's all in the rules. We haven't done that when we've put bars around what lawyers can and can't do and how they deliver legal services. And I'm alluding to the fact that we need a more flexible structure, an ABS type of structure. However that may pan out, I think is worthy of a lot of consideration and is something that the Law Society, if you allow lawyers flexibility, they will create that access to justice.
Beyond the role of individual lawyers and even ABS, how's the Law Society doing on the access to justice file?
I don't think it's done very well. I think there's a lot of talk. There's a lot of discussion and not a lot of action. I think we need to move into action. We need to create that system or ecosystem or opportunities for lawyers to be able to provide that level of access to justice. Part of it is a court issue, right? There needs to be greater discussion with the courts on that, but we have to do our part. We can't sit and point fingers like this.
Okay, with the courts, I take it you're talking about technology and issues like electronic filing of documents.
Yes, which is unbelievable to me that in 2015 that kind of system, which is very basic, it's not really rocket science, isn't in place.
Okay, so
in fact, and I've actually met today with someone who has that system up and running in Quebec and is looking to bring it to Ontario. So that may very well come.
Okay, so fast forward a month from now, and Bencher Kowalski has the opportunity to do something about electronic filing of documents. What do you do?
What I do? Well, I would meet with the government or get whatever process. I don't know exactly whether that's a treasurer-only issue or whether that's benchers can come together, but certainly make those overtures to the government immediately and say, hey, the technology is there. Go to the judges. Go to the judges, those judges who are very vocal about the fact that files are getting lost, that things are taking too long, and saying, here's a solution. Can you not mandate this?
Yeah.
Do we need to wait for someone else, or you as a judge in your court can say, this is how we're going to do things?
Yeah, I've probably shared these thoughts with you previously, but I'm certainly aware of a number of family law files that my office has participated in outside of Toronto, where the cumulative cost of sending people to file documents, and to Milton or to Newmarket, over the course of a file exceeds $1,000.
I don't know.
Simply in essentially courier and process serving costs that are entirely avoidable. From my point of view, that's low-hanging fruit in terms of an access to justice issue that can be solved with technology. Is the Law Society doing anything now beyond quiet lobbying?
Not that I can see, not at all. And I think the Law Society has to be leading the way. Someone has to lead the way. We can't let this continue on. And as you said, it's low-hanging fruit. It's not rocket science. The technology is there. All you have to have is someone to put it into place.
Well, that would also involve rules committees that simply, in the absence of a better system, permitting documents to be emailed to the courts, which many judges ask for now in any event.
That to me is, emailing, yeah, you could do that, but
it's not a gold standard. But
yeah, it's better than nothing. But like I said, the system that I saw actually this morning was very basic. It was an upload document system where everything could be tracked, could be verified that the document that went into the system is the same one that's in the judge's hand. It's verified transmission to the other side. The judge has it. It's all there, and it's all filed correctly by date or by counsel or whatever. And it's not. That should be very easily pushed forward, and that's something that the Law Society should do. And that's not even going to require a lot of rule changes.
So let's talk about ABS.
Okay.
You've been a champion of ABS and the experience in other jurisdictions like the UK and Australia. Why ABS?
Why ABS? Well, I've actually gone to the UK. I've gone to Australia. I've met with the management at Slater & Gordon. Met with a lot of lawyers in Australia who run ABS structures. I've corresponded with the former regulator in New South Wales, who was at first completely against ABS, but realized that with proper regulation, it is a manageable and a good thing. And I've been to the UK, met with individuals who are running ABS firms. What I like about ABS is it just gives flexibility. It's not for everyone. Not everybody uses it in all those countries. That's fine. But if it allows new players, new energy, new perspectives to create something that is in the public interest, that makes justice more affordable and accessible, then I don't see any reason to stand in front of it. Of course, it has to be regulated, and we've seen that's been done in two jurisdictions, and it's been in Australia since 2001, so it's not new.
Can you give a couple of examples from Australia or the UK about how ABS has created affordable options for consumers?
Well, the most obvious one that most people know about is Slater & Gordon, which is a consumer-based firm. So they're just the same things that you do. They do family law, they'll do real estate, they do personal injury, they do all these things. They're heavily invested in technology and process to streamline their process so that they can provide affordable services to Australians. And they all worked on fixed fee. Everything is fixed fee, so the clients know upfront exactly how much it's going to cost. Now, for those of you who are saying, well, it's driven by shareholders and this is bad, their profit motive. There are a lot of lawyers in Ontario who make a good living as a lawyer, and I'm sure they're driven by profits as much as anyone else. But the more interesting example from Australia is Salvos law. Salvos is short form for the Salvation Army in Australia, and the Salvos, 3 years ago now, using the ABS legislation, created Salvos Legal and Salvos Legal Humanitarian. Salvos Legal is a commercial firm. They do commercial work for banks and corporations. The profits from that firm are funneled into the humanitarian firm that does work for people who can't afford legal aid or have other issues. And they do this completely free of charge. They've done thousands of cases over the last few years at no charge to legal aid, no charge to the Salvation Army because it's self-funding, and no charge to their clients. And that's a model that they want to continue to roll out across Australia because there is a need, and that is a model I think that could work well here. If you contrast that with Pivot Legal out of Vancouver, which tried to do something similar within the confines of our regulations now, it failed after a few years. And it failed because they weren't able to have good business input. So it's not just about capital, it's about having good business people on your board of directors managing the business in a business perspective. Let the lawyers do the lawyer stuff, let the business people run the business in a way that allows it to continue to survive. And they were not able to do that. As a result, Pivot Legal, that law firm model, disappeared, and they do some other work in Vancouver now. So those, when you see these things, and when I see them, to me, I think those are good things.
So what are a couple of examples of the kinds of ABS firms that might emerge in Ontario if permitted?
I could see, well, I think Slater and Gordon's already publicly said that if we change the legislation here, they'd like to set up shop. They've already set up shop in the UK. And I think you will see in the consumer market that would be an attractive model for someone to create a greater footprint across the province. There's franchise options. These are things that are also attractive to the graying of the bar issue, where we have small towns where there are one or two lawyers who are ready to retire. A franchise option may be attractive to a new lawyer moving into those jurisdictions. It allows for greater operational efficiencies. And I think you'll probably see some interest at the sort of the mid and higher end of the market of corporate work. Like a Riverview Law type of model where Riverview does a lot of work for multinational corporations. It's day-to-day generic legal work that's not highly complex, but needs to be done, and they can do that at a better price point. So I think you'll see that happen. You won't see it at the very top end, you'll see it in the middle, and you'll see it in that consumer market. And keep in mind, lawyers have to work in these things, so it's not like jobs are being lost by lawyers. If anything, this may be an attractive option to young graduates.
I would describe myself as agnostic on the ABS issue right now, and like most of our colleagues out there, we're being barraged by emails right now from venture candidates who are sort of setting out in point form their top line comments. And one school seems to be the people who are saying, ABS, I haven't heard a single good reason why we should do it.
Yeah, which just shows you they don't really know very much about ABS.
Then there's another school that says ABS, I haven't heard a single good reason why we shouldn't do it. And
well, this comes down to decision making. Okay, this comes down to, if we're going to have the discussion in convocation, what are the rules of the discussion? On what basis are we making this? Is it just Mitch likes it and Garry doesn't like it, and we're just going to argue till we're blue in the face without any kind of, okay, well, what would be the threshold for this? Is it because ABS is not any worse? It doesn't create any more harm than what's done? So if you took approach that they use for approving drugs in Canada, right? Are there adverse effects? Yes. But there's always adverse effects to all the other drugs we have here. Are they greater or worse? Does that make, is that a reasonable reason to not have it? And why should the current system be the gold standard or the default position? Shouldn't it have to justify itself on the same basis that we're asking ABS to justify? So I mean, it's a decision-making paradigm or a framework that we have to think about before we come to this decision. You just can't, do this you're wrong, I'm right kind of thing.
Okay, is there a specific concrete proposal as to ABS that you would put out there to support right now?
Here's where I'm not fully decided on what form of ABS. What I can tell you is that both Australia and the UK have unlimited shareholder ownership. I'm okay with that. I'm not sure
Another non-lawyer shareholder.
right, unlimited non-lawyer shareholder. What I'm not really thought too much about, and if I'm a venture, obviously I will, is whether or not the second question, which is what kind of work do they do? Do they just do legal work, or do they legal work and something else and make it sort of a conglomerate? That I haven't really thought too much about at this point, and that's something that's part of the mix. Unfortunately, the ABS committee report I find is when you give way too many options, too many permutations, that causes problems, and so they've chosen to go that way. And so, the short answer is I don't have one exact concrete model because I'm willing to look at everything, and that includes whether or not you just do legal or you do legal and accounting, or legal and funeral homes.
Yeah, I think it would be easier for the profession to evaluate if we were actually talking about something concrete. But
Yeah,
we've been talking about ABS as this sort of vague, nefarious concept that has its friends and foes, but I don't think we actually know what we're for or against. Colin Lachance, one of your co-candidates, has made that point that what he favors is an open mind.
Yeah.
And I will go so far as to say I think we have nothing to lose by having an open mind. Are there regulatory concerns that are ABS specific that you would want to be mindful of as a venture?
My concern, ABS has to follow the same regulations as lawyers.
Yep.
What will actually happen is we will go to entity regulations as opposed to lawyer regulation. That's the first step. But as long as our core values are preserved and the regulatory, and they follow the same professional code of conduct, I'm not sure what more we should be, because that takes care of conflicts, it takes care of confidentiality, privilege, all these things.
I think if I were to articulate one fear about ABS, is that over time we'll get these too big to regulate entities.
Like Denton's? Like Denton's? or any of the national firms?
Yes, like those, only global and larger, and
DLA Piper?
And financed by non-lawyer entities who may care less about what law societies say about points A and B, particularly if points A and B are perfectly legal and appropriate in every other jurisdiction, but somehow Ontario says no. This is the sort of, this is perhaps the monster, the three-headed monster that I fear in terms of ABS down the road.
Yeah, I guess.
I think you're saying that the monster's already here and it's called Denton's, but I'm not sure.
I mean, if we're not afraid of that in the mega firm mergers that we've already seen, then I'm not sure it's a valid argument to say, but if it comes to personal injury, we have to be really worried about where we can allow everybody else in Canada to merge and merge and merge and merge. And let's face it, like Denton's, I don't want to pick on Denton's, but I guess I will because they're now the largest law firm in the world. Significant number of lawyers in China. What does that do to management structure? I know it's a variety. I understand this, polycentric issue, setup that they have, but at some point in time, at what point does Chinese management come in? And now Denton's Toronto is being said, massage it away. That's not really how we like to do things because in China we do it this way.
Okay, well, that's fine. So I'm happy to work with that theoretical example of too big to regulate. How do law societies handle that?
We have our rules and we have our core values. That's where we regulate. We have a complaints program. In fact, if you look at Australia, the complaints against ABS as a percentage are less than against non-ABS firms. So there's that evidence to suggest that a better governance structure and a better management structure is more focused on client satisfaction because reputation is important. And Are you going to throw away your reputation for short-term profits? Maybe, maybe not, but I think that's probably not true any more than it's true for a small practice lawyer to say I'm gonna do whatever I'm gonna do because I can make a lot of money on this one file.
Okay, so if your first meeting as a bencher, you're called upon to make a motion, make a resolution with regard to ABS, what is that motion?
First motion is let's put a structure around how we're going to make the decision. On what basis are we making this decision? Let's forget about yes or no ABS. It's like, on what basis would we allow ABS? So what do we have to achieve in order to do that? We can't just knee-jerk say yes, no. I think the ABS committee actually has to give us, as you pointed out, as Colin pointed out, give me an example. Say it's option 4. It will be regulated in this way, which will cover off all these things. You can have all the FAQs you want on this. This is what we're suggesting. But you're right. I think there has been a communication problem over this issue, and it hasn't been handled well.
Do you feel the discussion, which has now become circular, are we at the point where a specific proposal ought to be on the table to vote yea or nay?
Yeah. I think it's pointless to have. It's pointless to have 4 options. It's completely pointless because you're never going to get any kind of decent discussion around 4 different options. And even those 4 options you can mix around. I think even further than they have. I think it's counterproductive and it's not good decision making. Just give me an option. Tell us how we're going to figure it out. Then we have something concrete to think about, and let's think about the metrics upon which we're going to make that decision.
Okay, why don't we move on to the articling crisis?
Yes.
Where is it at now? Have we made progress, or are we about to take another step backwards?
Actually had breakfast or coffee with Chris Bentley from LPP, who's running the LPP program at Ryerson. It's such early days, right? I mean, it's been running, 6 months? It's not complete. There's been no analysis of data, even on their side, as to how it has finished out. And so the short answer is we don't know. I think it's foolhardy to come to any decision on that at this point because it's not complete. I know there's some benchers who have already said, or candidates who have already said, look, we're getting rid of this thing, it's horrible, articling is the best thing ever. I think the answer for Ontario really is a program that is consistent, gives consistent training, can be consistently monitored and measured so that everybody gets the same experience across the province instead of a patchwork kind of approach. My sense is it's probably going to be some kind of LPP type of program. How it will work will be, to the extent that we can keep it consistent and we can measure it. But that's where we're at. So, and again, the LPP, I'm not sure that there are any metrics in place now to say on what basis do we think LPP is good, other than let it run and we'll look at it in hindsight. I think that's a terrible way to make decisions.
Do you know anecdotally how that program has done in terms of placing students?
I think that they've placed all their students. I think the vast majority of them are in some kind of paid position, and the pay has varied. And I know very small, anecdotally, that the students are, the small group of students that I've been able to source some information from are quite happy with it and like it. They think it's valuable and gives them, some skill sets that you don't get during articling. You have to expand that more. But I think it's an interesting concept, and it has to be, looked at carefully and let it run its course and evaluated fairly instead of being just tossed off the table.
And what is its course? 3 years?
3 years. So, but again, if the benchers don't know on what basis they're going to evaluate it from 3 years from now, I don't know how you make that decision 3 years from now.
How should it be evaluated? What's your position on that?
I think you have to look at first of all, consistency of training. I think you have to look at the number of people that have gone through the program, and I'm assuming that everyone can go through this program. I don't think there's been anyone who's been shut out of that program, unlike our I think you have to evaluate the pricing. You have to evaluate the consistency of instruction in it, and make your decision based on that. But consistency for me is a big thing. If the training is not consistent, and the mentoring is not consistent, and then there's not much of a program.
You were in favor of the LPP program.
Yeah.
In the initial discussion.
I thought it was I don't like a dual track because it creates, a tier. Whether there's a perception of tiers where the articling students are the really good students and everyone else is, the people who couldn't get jobs get LPP. So I don't like that. I think that's unfair. And when you run any kind of dual system, you're going to run into that, and that's not fair to the students at all. And so my view is I can live with it as a pilot, but at 3 years we have to make that decision to go only one way instead of keep running 2 horses.
So you would potentially be an advocate of eliminating the articling program altogether then?
I'm okay with that. If the LPP program, based on whatever metrics, convocation comes up with, I'm okay with that. Because at the end of the day, all that matters is people are properly trained. That's the metric. And if that can be done outside of articling, why not?
Yeah, we're on the opposite side on this one.
Yeah, no, that's that's fine. And everybody, see, the issue is everyone has a different articling experience. Right? There are lots of people who said articling was the worst experience. I learned nothing. I did, a whole bunch of work that I didn't need my law degree for, and all of a sudden, magically, as soon as I got through my 8 months or 12 months or whatever, time it was when you went through, I'm not sure I'm that much well prepared to practice. And other people will say, oh my God, it was the best experience of my life.
Yeah, well, I'm sure that among the articling students that have traveled through my firm, we would have an equally varied response as to how good or bad a year
They
would
would have
be.
said this was the best experience.
Some would have, Mitch.
and it's also going to be file dependent, right, in our position, because you're going to say, the year before, to your point, in your office, that last year's student may have had great because you had a lot of really, really good files. This year, your files are just kind of, not too stellar. They're day-to-day work or stuff that the articling student wouldn't be as involved in maybe as they would have last year, and that's not your fault. It's not the student's fault. It's just the nature of the practice. So, how do you get around that? I think you have to structure a program where people year in, year out know this is what I'm going to get.
Well, I think that whether it's articling or an alternate program, the reality is that a student's success often is dependent on the degree to which that student embraces the program.
Sure.
And that student's own enthusiasm,
Yep.
soft and legal skills that can combine to make a good or not so good experience, as well as just simply the fit, which is going to be a problem in either of these tracks. Discipline. Roya. Didn't have to say anything more. Comment. Discipline. Goya.
Okay.
Goya. Comment.
I think that the Law Society has to be more thoughtful about how they deal with discipline cases. Whether it becomes too personal and we're going to get somebody, and it doesn't matter about anything else, cost be damned, we're going to spend whatever it's going to take because we're going to make an example of someone. I think that needs to change. it's at some point you have to sit back and say, does this make sense to be doing this, given everything else? You know, we had a bencher. I mean, Mr. Roy brought a motion last year. Law Society wasted a lot of money on that as well, on asking a bencher to be removed because of a conflict. This was a bencher whose firm does a lot of work for the Law Society. That in itself, to me, is the most obvious conflict. And one of my suggested reforms in terms of structure is, if you're a bencher, your firm doesn't do work for the Law Society. You choose. You either want to be a bencher or you want to get work from the Law Society. You can't do both. That's the way it works in the real world. And so for that individual not to step down and just let someone else take his place on the panel, I think was not a good decision. And I think that kind of thoughtfulness needs to pervade in the Law Society.
Does the Law Society make an error by venturing into issues like civility in its discipline process? And if it does, what are the alternatives?
Yeah, exactly. Great question. Civility is important. I just don't, if you don't have bright lines and markers around it, I think it's really difficult to pursue. A lot of litigators will tell you that it's war, right? Criminal lawyers will tell you it's war. We are fighting, to the death, whether or not that is correct or not, but that's certainly the prevailing mood. And I don't know, quite honestly, how you temper that. And I don't know what bright lines you can put around behavior that say, like, this clearly crosses the line, everything else is okay. I think it's just too vague.
Well, it is, and
I don't know what the answer is.
I don't either, and I think that I can say that there have certainly been times in my career where I've encountered lawyers behaving far more badly than Mr. Goya in the ordinary context of litigation, and basically turning the other cheek is often the best and most mature response to it. You mentioned the cost to the Law Society, but the cost to the individual who has to defend one of these complaints, including the cost risk of being required to pay Law Societies several $100,000 in costs. It tells me that this monster has grown and it's out of control. Perhaps there should be a different approach to discipline for these kinds of softer offenses.
Yeah, the discipline, the whole process, to me, seems to be a great idea in 1849, and has not really moved beyond that. I'm not sure that benchers are always the right people on some of these panels, where especially benchers who really have no experience in certain areas of law to understand. I'm thinking particularly in mortgage fraud cases, where there's not a lot of experience there, yet you have benchers sitting in judgment on these matters. Is that really a good idea? Is there some better way we can do this? And,
I suspect you have some ideas about a better way.
Well,
should it go to the judges?
I'm not sure that benchers are really the best people to be on discipline panels. I think it makes more sense to have a group of individuals who are subject matter specific to be dealing with these issues, and could probably dispose of them far quicker and more efficiently than a group of benchers who know nothing and have to be brought up to speed on so many different intricacies on how certain matters go, which blows out the timelines and costs. So I think some kind of specialized tribunal where you have a group of ex-judges, arbitrators, what have you, dealing with that might not be a bad idea.
Do you see any initiatives coming from you in the 4 years ahead as a bencher to deal with discipline and to rationalize the system?
Yeah, I would like to look at that. I mean, there's a full plate of stuff that I've talked about, but certainly I know this is an issue that keeps flaring up from time to time when people mention it to me, and I think we have to deal with it. So, yes.
The election itself, what has it been? We've had the opportunity to talk to lots of people. And
It's way too long. It's far too long, and it probably all the candidates will say it's far too long. And the voting process, I think it's great that we've gone 100% to electronic voting. I'm still mystified at why we need 17 days of voting as opposed to just 5, or maybe even 2 or 3, like in normal elections. But be that as it's may, I think hopefully that's a change that will come through next year. The process will be better. But it's been fun. I've been received a lot of support across the province, so I'm quite happy about that. And certainly it really creates a lot of expectations on me that I want to fulfill should I be elected.
if elected, what's your priority among all these issues? What's the one thing that needs to be done right away?
Yeah, what are the, like, I'm a big 100-day guy. Like, I want, like, the 100 days. I think in terms of milestones and marks, and thinking about at the end of 4 years, what would I think is failure? So first 100 days would be to deal with some of these structural changes. So, the election, get it down to 5 days. That's easy. That should be easy. Getting rid of light benchers, that should be not particularly hard. Allowing for election expenses to be capped so that we can get better and more diverse people who have an honest chance of winning a Bencher election. That should be fairly easy. So those kind of structural issues. ABS and LPP will play out during that 4 years, and I think, and then the discipline, as you mentioned, I think if there was no change in those 3 issues beyond what we have now, then I would think that would be a failure. So quite frankly, personally, I'll be blunt with you. If LPP was thrown out at the end of 4 years and we just went back to articling in some shape or form, I would consider my term to be a failure. If a more flexible way for lawyers to practice in some kind of ABS type of morphing, however that may look like and how it's regulated, I would consider that a failure as well. And if the discipline process doesn't change, that's failure to me. So that's, I think all Bencher candidates should be thinking of that. What does success look like 4 years from now? What does failure look like? And move on that. This is not, a job where it's just my time to do it. It's my time to step up, whatever that means. It's like we have to have defined goals and figure out what success is, what failure is. How are we going to get there? But this isn't a day-to-day, hi, I'm a bencher, and, make some decisions and life muddles along. We're beyond that. We need a very progressive, forward-thinking, and active convocation.
Paralegals.
You know what I think about this.
I don't know what you think about this. Okay. You use my picture everywhere you go, but I don't know what you think about this.
Paralegals, I think, are vital to access to justice. I don't know how you could argue against that. I think that paralegals should be allowed to go as far as they can go, based on skill level. And I think actual law society shouldn't even regulate paralegals. There should be another body regulating them. I think there is a big conflict when lawyers and the law society is regulating essentially competitors of ours. I think that's not fair to the paralegals. I don't think it's a healthy environment. And certainly I've seen some trepidation from paralegals saying we don't want to get the lawyers too upset. That shouldn't be the case. That's not how we should be operating. That's it.
I believe that paralegals should be in our family courts as a solution to the self-rep problem that's articulated by judges and counsel alike. Is that something that you're prepared to look into as a bencher?
I'm prepared to look wherever paralegals can add value, whether it's in family courts or civil courts or whatever area of law makes sense and that they have the training for. I have no objection to that. I think it's what we should be looking at it, what's in the public interest.
Yeah, and
if it works for the clients, then it should work for us.
yeah, well, why not have a paralegal accreditation process for various areas of the law? That's simple.
Yeah.
So I would advocate that. You're on board?
I'm on board.
Okay. Any parting comments? Final statements?
Final statements. No, I think I've said this time and time again. The convocation has to be active. It has to be progressive. We have to realize that we're in a new century. We have been for 15 years, ladies and gentlemen, and we have to take advantage of the technology, of the processes, of the different ways of doing things from around the world to make us a better profession for the benefit of the public. And I ask for your vote, and thank you.
Well, Mitch, we don't always agree, but I think you have become one of the more refreshing voices within our profession. Bringing these issues up, not being shy about the debate, and I think the profession owes you a great vote of thanks for that. You have my support, whether I agree with you or not on issue to issue, and I wish you all the best.
Thanks very much. Appreciate it.
Thanks for joining me today.